Hi, I'm Nick Alcock, the owner of Alcock & Associates. There's so many times we get calls from clients who say CPS is calling and the allegation has been made that the child is claiming that they were molested, that they were touched. And CPS wants to get information about what's going on. What you need to know is that CPS runs a department which is totally separate from the police. But many times CPS will work with the police to get information, and they'll try to get that information sometimes by threat of force. So in many cases CPS will come to a mother, for example, and say, look, you need to tell us what's going on here, otherwise we're going to take your kids away. You need to say what the father is doing. And unfortunately, many times, because they hear the mother hears this threat, the mother hears, oh my goodness, they're going to take my children away, they kind of sign whatever they want to, whatever the CPS is presenting to them, or they admit to whatever CPS wants them to admit to. Then later, a day later, they realize that the mistake that they made. What I always advise people to do is this: if an allegation is made about sexual conduct, and if CPS or if the police are coming, you just absolutely need to know that you have the right to speak with an attorney, and you should not submit to a polygraph test. You should not submit to really any questioning whatsoever, because in most cases that's the evidence, the only evidence that could be used against you. There are so many cases that we've seen, and we won a case recently where the police interviewed a gentleman for 4 hours, asked him over and over and over again, did you do this? He denied it over and over and over again. Then finally, at the end of this interview, the police officer looks at this gentleman and says, look, this girl is really been damaged by someone, and we don't necessarily know who it is, but unless you confess, she's never going to get better. She's never going to repair her shattered psyche. And so this gentleman says, all right, well, if that's what you want me to say, and if that will help her, then fine, I guess I'll tell her that I did it. I didn't do it, but I'll tell her that I did it. He actually got arrested, and he was thrown in jail, and he was thrown in jail for several months. We took the case, we took it to trial, and we won. There was no other evidence against him, but it just was amazing that a 4-hour interview, deny, and then finally they used that tactic to try and get him to confess. It really wasn't a confession, but you'd never know that by hearing the prosecutor in trial. You never know that there was actually 3.5 hours or however many hours of denial before he confessed. Just be aware that in these cases, in many cases, they're going to use a number of different tactics. They're going to say things such as, we're going to take your kids away unless you confess, or the child will never get better unless you confess. And unfortunately, good people find themselves arrested for these types of offenses. In Arizona, you can get 35 years, you can get 40 years for one single conviction with no priors. If they claim that you touched the genitalia of a child under the age of 15, you're looking at that type of time. So if ever someone comes knocking on the door, police officer wants to know, hey, can you answer some questions about this allegation this girl is making, call an attorney. My name's Nick Alcock. My number, 602-989-5000. We're available anytime to answer any questions you have about these types of cases. Thanks so much.